These are the 6 key milestones in a standard sales process of a feasible property by Group 31. Engaging a vendor client. When engaging a potential client, it is important for the agent to ensure that it is clear that they will aim to provide the best outcome for both parties. As such, the real estate agent must exhibit the attached rules laid out in the real estate agent's professional conduct and client care rules. By carrying out this appropriate conduct and treatment of their potential client, it will ensure that they themselves are abiding by the minimum standards under the law and allows the potential client to observe the strengths of the agent they may choose to market their property. The Real Estate Agencies Act is another key piece of legislation that will help protect the interests of the potential client and help regulate the agent's conduct to prevent unnecessary issues when carrying out the sales process. While attempting to engage with the client, it is important that the agent exhibits the terms of this act to promote the integrity of their work standards, which will subsequently reassure the client. As seen in the case of Kemp and Scoble, it is key in the successful engagement of a client that the agent has a comprehensive understanding of their obligations or duties and how breaching such terms can produce a case of negligence and incompetence from the clients.
The next key milestone is taking the vendor's property to market. Rule 5.1 of the REAA Act requires that all agents, when carrying out their real estate agency work, to always demonstrate such exercise skill, care, competence, and diligence at all times. Section 72 deems where the agent's action falls short in some aspects. On the other hand, Section 73 constitutes a serious negligence or incompetence that is highly disgraceful by professional standards. Mr. and Mrs. Baker versus Hamish Strom is one example. Mr. Strom failed numerous standards, including not providing the appellants an opportunity to seek legal advice or even recommend one. He was deemed guilty of Section 72 as he fell short from negligence and competence by professional standard. It's absolutely essential that you must have a reasonable basis when making a statement. An unsubstantiated statement without supporting evidence is considered an offence under 12A and 40 of the Fair Trading Act. Section 12A refers to any substantiated representation about property requires evidence. Section 40, on the other hand, make that misconduct an offence. Therefore, you need to be vigilant and ensure that the statements you or the agency make are accurate, genuine, and substantiated.
Receiving potential offers from purchasers. When receiving potential offers from purchasers, it is required that the agent is to pass on any potential offers to ensure the vendor gains the best purchase price. While going through the process, the agent must follow the professional conduct and client care rules as well as the Fair Trading Act. Failure to do so will result in a breach of contractual obligations and duties. The agent will also be breaching the fiduciary relationship between both parties. As seen in the case of Marketu Estates and Rob, there was failure from Rob, who was the agent, to inform the vendor of a potential offer based off unconscious bias, which resulted in Rob breaching his obligations and duties.
Entry into an agreement for sale and purchase with selected purchaser.
Client and customer care is imperative to ensure client satisfaction is met by maintaining appropriate practices and avoiding unsatisfactory conduct. This can be achieved according to the Real Estate Agents Act Rules 2012, Section 9.7, where before signing any sort of contractual document, the licensee must recommend that the person seek legal advice, ensure the person is aware advice and information may need to be sought out, while also providing a reasonable opportunity to obtain the advice. Section 10.5 and 6 also states before an agreement can be made, the licensee must explain and set in writing the conditions under which commission is paid and calculated.
Under Section 123 of the Real Estate Agents Act, it is important that the agent acknowledges their obligations regarding the deposit for their client's property and that they understand they cannot pay out the deposit for 10 working days if they are in possession of the funds. However, this holding period may be shortened if there is a court order or an authority assigned by both parties to the transaction. It is important for the agent to understand their possession of the deposit as a stakeholder, so to prevent unnecessary ramifications, they must exhibit a clear comprehension of their obligations to the client and the necessary deposit.
Settlement of a sale of a property. Section 126 of the REAA states that agents are not entitled to commission or expenses unless they fit the criteria stated. This must be communicated to the client, and failure to do so may result in breaches of certain acts. This was seen in the Baker v. Strom case, as there was no explanation to the client and they were found guilty of unsatisfactory conduct.
ADLS Sales and Purchase Agreement provided for pre-settlement inspection for the purchaser. The purchaser is able to inspect the property the day before the settlement date to ensure that the property condition remains the same as it was during the signing of the SPA agreement. When inspection, the vendor of the property must tender a settlement statement to the purchaser or their lawyer within a reasonable time prior to the settlement date. The possession shall be given and taken on the settlement date. Any outgoings and incomings are responsible by the vendor. Once the title of the property has been transferred to the purchaser, the vendor is required to deliver all copies of the key to the purchaser. After this point, your duty as a real estate agent is no longer required.